All right, let's jump in and get started. Thanks everyone for joining. My name's Logan Reed. I'm the global co-chair of the Antitrust and Competition team here at Hogan Lovells in Washington, D.C. And I'm really excited to have this great team of people from our global Hogan Lovells team to talk with you all about the topic of ESG, or environmental, social, and governance issues in antitrust enforcement. And it's an area that sees pretty significant divergence between the U.S. and EU. And even within the U.S., there's a politicization of this issue that makes it even more complicated for us to know exactly where the fault lines are as we think about the application of antitrust principles to ESG issues. Maybe we could start with our panelists introducing themselves, and then we'll jump in and we'll talk about the application of antitrust principles in several areas: agreements, merger control, unilateral cases, or abuse of dominance in the EU. And as we go, we'll be hearing from people in various parts of the world. I should also mention a couple of things just as housekeeping matters at the outset. One is that this webinar is being recorded, and you'll have an opportunity to see the recording at the end. Also, there will be CLE credit available for those of you who are interested in that. And you should have received, I believe, a CLE form already. You can also receive one afterwards, and we'll share a code with you that you can use to get that CLE credit. We would also love for this to be an interactive session. And so if you have questions along the way, please feel free to add them in the Q&A. And we will try to reserve some time at the end for questions. So with that, maybe we could go through some quick introductions. I see Francesca is first on my screen, at least. Could you introduce yourself, Francesca?
Sure, thank you, Logan. Good afternoon, everyone. I'm Francesca Moretti. I'm a competition lawyer at Hogan Lovells Milan office. And after the adoption of the Green Deal by the Commission at the end of 2019, I have devoted quite a lot of time and attention to issues connecting competition law with sustainability.
Great, thank you, Francesca. Elena, could you introduce yourself?
Yes, of course. Thank you, Logan. My name is Elena Wiese. I'm an antitrust partner in the Düsseldorf office of Hogan Lovells. I'm quite into these ESG issues also for personal reasons, and today I'd like to discuss with you how ESG might impact merger control. So thank you for being here today.
Thanks, Elena. And Ches, could you introduce yourself?
Yeah. Hi, everybody. My name is Ches Garrison. I'm a counsel in Washington, D.C. In Hogan Lovells' Government Relations and Public Affairs group. I previously spent about 10 years on Capitol Hill, including 6 years on the Senate Judiciary Committee, which has jurisdiction over antitrust legislation and investigations. And so here to sort of give the U.S. a little bit of the U.S. perspective, and also sort of the political side of things, which, as Logan forecasted, are important, especially in an election year. So looking forward to it.
Great, thanks, Ches. Let's flip to the next slide, and we can dive in, starting with a conversation about how some sustainability or ESG issues could be implicated in agreements or combinations of cooperation between competitors in an industry. Francesca, could you lead us off with the EU perspective?
Thank you. Sure, Logan. Next slide. What are sustainability agreements? Sustainability agreements are any type of horizontal cooperation agreement between competing undertakings to pursue sustainability objectives, irrespective of the form of cooperation, whether it's verbal or written, irrespective of a number of participants. They typically pursue goals which are aimed at achieving economic, environmental, and social development, that is sustainability in broad terms. And why are we concerned about the relationship between sustainability agreements and competition law? Because frequently these agreements are entered into by competing undertakings in order to overcome the so-called first mover disadvantage. And they might entail restrictions to competition. So the big question mark has been, given the Green Deal, should any type of cooperation agreement aimed at pursuing sustainability objectives be considered compatible with competition law rules or not? And the answer, of course, is no. Sustainability agreements must go through the same type of analysis as any other horizontal cooperation agreement to see whether or not they are compatible with competition rules. Next slide, please. Sustainability is a hot topic throughout the world. There are many competition authorities which have become extremely active in this area by adopting soft law rules and also by taking a very active stance in deciding upon cooperation agreements. The Japanese Fair Trade Commission, which has adopted sustainability guidance, has very recently cleared an agreement by 5 petrochemical manufacturers, which is aimed at basically regulating the operational life of a petrochemical plant with aiming at zero carbon emissions by 2050. The CMA has also adopted sustainability guidelines, but the core of our presentation today will be what has been done at the EU level. The EU Commission has finally adopted at the end of 2023 its long-awaited guidelines on sustainability agreements, which are inserted into the framework of the guidelines on horizontal cooperation agreements. Next slide. We should also mention the fact that many other competition authorities also at the level of EU member states have adopted guidelines or have implemented the instruments to deal with sustainability agreements, and we will see a few of them. As said, a specific chapter of the horizontal cooperation agreement guidelines is devoted to sustainability agreements. The attitude of the EU has been very cautious if compared to that of the competition authorities in some member states. In parallel, there have been guidelines adopted concerning sustainability agreements in the agricultural field, and they differ to some extent. They are more daring in that connection. We will see how. Next slide, please. Now, when we are facing an horizontal agreement affecting sustainability, then we have to apply the general rules governing the assessment of horizontal agreements under EU law. The principle is embodied in Article 101(1) of the treaty, which prohibits restrictive agreements. Now, if the sustainability agreement does not affect any of the parameters of competition, such as price, quality, quantity, choice, and innovation, then there will be no issue and it will be compatible, of course, with the EU competition law. But what if it does affect these parameters? Well, the EU approach is that if the agreement mainly aims at pursuing the sustainability objective and is not a way to disguise a cartel, then the agreement will not be considered as restrictive per se or by its object, but it will have to be assessed based on its effects on the market. The guidelines have a soft safe harbor for agreements setting forth sustainability standards, which is very frequently the way companies get together to achieve sustainability goals. The guidelines set 6 conditions that must be all satisfied for the sustainability standard agreement to be compliant with competition law rules, and they basically relate to, of course, the absence of any restriction to competition, the absence of any sharing of confidential information, competitively sensitive information, the fact that the standards must be adopted in a fair and transparent manner, that companies must be free to abide by the standards and adopt the standards or not. Next slide, please. But when we are outside the scope of sustainability standard agreements, how does the reasoning of the EU Commission work in dealing with sustainability agreements? It works by applying the so-called legal exception principle, which is set forth in Article 113 of the EU Treaty, which, as known, sets forth 4 cumulative conditions that must be respected for an agreement that has an impact on competition to be nevertheless considered compatible with the EU competition law principles. In the sustainability guidelines, the Commission has adapted these 4 criteria to the area of sustainability agreements. And therefore, the efficiency gains that must be produced by the agreement in order for it to be compatible with the EU competition rules must affect the sustainability parameters, such as the use of less polluting production or distribution technologies. They must bring about improved conditions on production and distribution, more resilient infrastructure, better quality products. The restrictions in the sustainability agreement must be indispensable to attain the sustainability objective in a more efficient or in a faster way. There must be no elimination of competition. I deal with the 4th condition because the 3rd one is the trickiest one. For example, if competitors decide not to use a particular polluting technology, they must remain free to compete on the price of the product and the quality of the product embodying the less polluting technology. Last but not least, the pass on to consumers rule. Article 113 of the treaty provides that agreements restrictive agreements must reserve a fair share of benefits to consumers. So there must be a benefit passed on to the consumers which are affected by the restrictive provisions in the agreement. The Commission has adopted a very prudent approach in that it has agreed to take into account only those benefits that accrue exactly to those same consumers which are negatively impacted by the restrictions. There had been a lot of pressure on the Commission to adopt a wider concept of benefits, in particular, taking into account out of market benefits that could accrue to the society as a whole, which is a stance that has been taken by some of the competition authorities at the EU member states level, but the Commission has decided to stick to a narrower approach and consider only benefits to consumers which are at the same time affected by the negative provisions. There is a possibility to take into account out-of-market benefits, but it's quite remote and subject to many restrictions. Next slide. Now, has the Commission applied the sustainability guidelines in practice? Not that we know. However, it has adopted before the adoption of the horizontal cooperation agreements guidelines, a very important and interesting decision in 2021, which has also to do with green transition and sustainability. It is the ADI Blue case or the car emission cartel case. It is a very complex case, which definitely cannot be summarized in a slide. and it covers a lot of very interesting aspects under a competition law standpoint. But for the purpose of our webinar today, what I think really matters is that the Commission has considered that the 5 car manufacturers that were under investigation they possessed individually the technology and the capacity to reduce car emissions to an extent even larger than what provided by the applicable emission standards. And they had agreed basically on technological standards that would simply mirror the applicable standards, restricting their ability to compete for even greener cars, to define it or to describe it in a very simplified term. So it is somehow an indication that the Commission will not accept that companies that can achieve better or faster the goals set forth in the Green Deal limit their competition in the sustainability area. Next slide, please. Now, as said, there are many competition authorities at national level which have taken a very active stance with respect to sustainability agreements. And I selected a few out of the many decisions. A very active competition authority is the Bundeskartellamt, the general competition authority, the German competition authority. Germany has not adopted sustainability agreements guidelines. However, the FCO has been extremely active, and it has, for example, in the selected case here, approved a working group by major food retailers aimed at promoting living wages and incomes for farmers producing bananas in Ecuador. And the approach of the FCO has been that there were no sensitive information exchanged, and that basically the standards were aimed at making sure that the banana producers in Ecuador complied with local laws, in particular as regards statutory minimum wages. Same case decided by the Belgian competition authority, allowing once again the agreement to take place and to go forward, but with a different approach. The Belgian authority basically applied the safe harbor criteria that I described above, which are included in the guidelines adopted by the EU, although the case was decided before the adoption, and basically found that the agreement satisfied all the 6 cumulative conditions. There was no restriction of competition, no competitively sensitive information exchanged. There was no recommendation how to pass on the changes in the cost to end consumers, no recommendation of prices, and in any event, the performance of the agreement was closely monitored, and data were monitored by third independent parties. A very interesting decision has been adopted by the ACM, which is the Dutch competition authority, extremely active and innovative in applying competition law rules to sustainability agreements. The agreement here concerns Total and Shell, and it concerns the setting up of a storage for CO2, capturing and storing CO2 in an empty gas field. Basically, what the Dutch competition authority concluded is that it was indispensable for parties to get together for the project to succeed because of the important investments and technologies involved, that there was a benefit to consumers because, of course, there would have been less CO2 emissions. And also that although the parties would have offered to the customers in a giant manner the 20% of the storage capacity of the plant, they would be free to compete regarding the remaining 80% of the capacity. So there was no substantial restriction of competition between the two competing companies. Next slide. A negative decision has been adopted by the Bundeskartellamt in a case concerning milk producers. Milk producers were proposing to agree on a surcharge to be paid to farmers for raw milk product. And they claimed that this would have somehow improved the domestic production of milk. However, the Bundeskartellamt considered that this was a price cartel, very simply and clearly, that the surcharge would have been passed on to consumers, which would have paid a higher price for milk. And that there was basically no evidence whatsoever, not even a mention that this would have somehow brought to milk being produced in a more sustainable manner. So it stopped and did not allow the parties to go ahead with this agreement. Next slide, please. Is the Commission applying sustainability guidelines? Is the Commission dealing with cases on sustainability? The Commission has opened an investigation in 2022, so before adopting the guidelines, but of course, there were documents in place even before then. This investigation concerns alleged collusion on vehicle recycle companies, on payments to vehicle recycle companies. It deals with the vehicles that have come to the end of their functional life and therefore become wastes. And it seems that the Commission considers that there might be restrictions of competition brought about by the agreement as such, but it has been ongoing for 2 years now, and there is very little information about this case, at least public information. We will see how it evolves. Next slide, please. So what should companies keep in mind when they are seeking for sustainable cooperation, when they are joining forces to obtain sustainability objectives? First of all, as said, there are many differences on a local level. So they should first verify where is the impact of their agreement going to be produced, and this will lead them to understand what is the authority in charge and what kind of rules will be applied. They will have to go through a self-assessment of whether or not the agreement is restrictive of competition and can benefit from the legal exemption rule. If they are unclear about that, and it is very difficult because we are, exploring a new field, as Logan was saying before, in certain jurisdictions, and they may seek for advice by the competition authorities. But the good news are that sustainability objectives are taken into account in applying the legal exception rule. So this is something that will be developed in the future and then can be counted on. Thank you.
Thank you, Francesca. And on the US side, we have a very different story. We don't have any guidelines. We don't have any safe harbors. The general antitrust principles that apply in every investigation of an agreement or cooperation would apply in the context of a sustainability agreement. But as Francesca was discussing some differences at the national level within European member states, We do see some differences in the approach in the U.S. at the state level as well. Ches, can you kind of run us through what we've seen on sustainability investigations in the U.S.?
Sure. Well, actually, the car emissions case that Francesca mentioned sort of has a little bit of an analog in the United States. In 2019, under President Trump was very critical of a decision by four automotive manufacturers to comply with state California emissions levels, which are more stringent than the levels set forth by the Trump administration. So he was critical of that. Shortly after he voiced that criticism, the Department of Justice Antitrust Division opened up an investigation into the auto manufacturers, looking to see whether this decision to comply with the California emissions guidelines constituted a horizontal agreement in violation of the Sherman Antitrust Act. The decision to open the investigation drew a lot of criticism from Democrats in Congress and in the states, and I think was kind of looked at with a little bit of a raised eyebrow by the antitrust bar. There really wasn't much precedent, or it didn't seem like there were much facts supporting that there was any kind of antitrust violation going on. The DOJ quickly dropped the investigation in 2020, but that is sort of an example and stands as an example of a way that as DEI and ESG policies come under increasing scrutiny sort of across the spectrum, especially on the Republican side, there's a willingness from President Trump and some of the more populist Republicans to use sort of all levers of government to enact or pressure the private industry into adopting different policies. We've also seen this sort of at the state level, where Republican state AGs have sent letters to financial services companies, accounting companies, banks, in sort of different waves of letters and investigations, questioning decisions to either divest or not invest as heavily in the fossil fuel industry, into making commitments to get to net zero emissions by 2050, and also by agreeing to be more forthcoming in sort of climate disclosures outside of the rulemaking process in the SEC right now. So those are just sort of examples of how DEI can sort of fall into an antitrust investigation. Right now, there hasn't been a lot of action on these, just they were sort of in the investigative stage, but they have yielded some pressure. A number of companies have dropped out of commitments related to climate. So it just sort of shows that as these issues in the United States continue to be, highly partisan, highly political, it can really put companies in the crosshairs, and they need to think carefully about how they go about agreeing to these, how they go about getting into the decisions to make these commitments, and how they go about following through on them.
Yeah, thanks, Jess. It's a great example of how just getting the antitrust answer right might not get you in the right place if you're not thinking about the political considerations at play. Let's transition into another topic, merger control, and how sustainability or ESG factors can be relevant in an assessment of the potential anti-competitive effect of a transaction. Elena, could you start us off with the description of the process in the EU?
Yes, of course. Thank you, Logan. And this is really something that many of you might not have yet on the forefront of strategic decisions when it comes to merger control, but indeed ESG as of yet plays a role in EU merger control. So next slide, please. We have briefly summarized for you a timeline of events that have happened so far that impact EU merger control when it comes to sustainability. You all know that 2019, we had the big European Green Deal. And really, the message is that everyone has to play its part, be it private persons or public persons. And Commissioner Vestager also said that competition enforcers have to play their part in achieving the goals of the European Green Deal. And so in 2021, we had a competition policy brief. This is something that the European Commission issues quite regularly. But this one really had the issue of competition policy in support of Europe's green ambition to a matter. And this is really interesting because it tells us a bit of the insights of the European Commission's thinking. And it also stated some stakeholder proposals on how European antitrust law can play a role, and not only with regard to state aid law or antitrust, but also with regard to merger control. 2 years later then, this was very briefly summarized with regard to, in particular, EU merger control and sustainability issues. So it gave us insights on the Commission's thinking on green mergers. Green mergers, something quite new for us here, on green remedies, the need to take into account consumer preferences for green products when it comes to market definition, and the importance of enforcing and pursuing innovation theories of harms, also in merger control. Francesca has just a minute ago briefly talked us through the AdBlue case, which was an innovation theory of harm, and we will also now see this when it comes to merger control. And just last month, the Commission issued a new market definition notice. The old one, as we will see in a minute, is from 1997. I was quite young at that age. And now it's completely new, very much longer, and it's taking into account sustainability and innovation. So we would like to take you through a deep dive of the market definition on the next slide and why green product markets will emerge. As just said, there is a need to consider consumer preferences for sustainable products, services, and technologies as a differentiating factor. We all experience this when we do grocery shopping, for example. Do I buy conventional bananas or do I buy fair trade bananas? This is a decision that all of us have to make and that we all do each day. And the Commission acknowledges that we do it now. But the former market definition notice that we had to adhere to was based on a traditional methodology. It was largely based on price and on the final stages of a distribution process to determine demand-side substitutability. And why exactly do we do market definitions? Antitrust lawyers define markets all the time, not just to assess how likely it is that a merger will be cleared, but also for collaboration agreements, but also to see whether there might be a dominant position and whether you might need to adhere to different rules. But now things change. The Commission will not only look at the products that you put on the market and that your competitor puts on the market. It will also look at the innovation potential that you have. It will look at whether you do R&D and whether a company that you want to merge with or whether there is a company that you want to collaborate with also has this innovation or this R&D potential. So now various more parameters of competition play a role when it comes to defining markets. Next slide, please. So away from this test, whether there is a significant price increase and whether this would make consumers change to another product, have also been dealt with in the past. And one case is the bananas case. So bananas play an important role, I think, in antitrust law. Francesca just explained one. Here's another case. It's regarding Chiquita. And in that case, I think it's from 2015, the Commission said that it considers on the basis of the replies received during the investigation that it is justified to segment the market between conventional bananas and organic bananas. So there were really two markets. In the case concerning coffee, the Commission also considered that there is non-conventional coffee and conventional coffee. Both taste the same. Are they in the same market or not? And here the Commission stated that there are indeed in the same market, there are substitutable, but as we will see in a minute in the competitive assessment, they are not very close competitors within the market. And quite interesting also in GE Alstom, it was kind of a different story because there are very many ESG regulation when it comes to turbines. And here the Commission stated, among others, technical requirements appear to be strongly affected by environmental regulation and climate conditions. And these environmental regulations sort of led to dividing the market in this case. What's really important then for you is to really consider how you define markets going forward and to look at whether you have to take into account these new parameters of competition, because these can make markets a bit narrower, but also wider, depending on how you would like to define them. Next slide, please. So market definition is not all of it. When it comes to mergers in the competitive assessment, the Commission looks beyond substantial market shares. It will carefully examine whether merging parties are close competitors. And as is stated in the horizontal merger guideline, products may be differentiated within a relevant market such that some products are closer substitutes than others. And this in the past was also very much done based on price and on output principles. But now we see a shift here. In particular, where one or more parties to the deal is a green innovator, closeness of competition in terms of their R&D efforts and capabilities are of importance. And there's a really recent case on that. It's Zika. And there the merging parties were both strong innovators with regard to green R&D. And this was seen by the Commission as important to meet the goals of the European Green Deal. In the end, the parties had to divest a very important green innovation business. This was taken on by a remedy taker to be able to clear the deal. So as can be seen here, the Commission's objective is really to avoid a loss of green innovation for the European Union. Next slide, please. Equally relevant is the innovation theory of harm. As you know, competition law looks at whether there is an impediment to competition. How is competition affected? And this has largely been done based on price. But innovation can bring greener technologies, products, and services. It can bring more quality issues, more sustainable issues on products. So there is a broad consensus that the Commission should enforce and pursue innovation theories of harm as much as possible in merger cases. And the question is, does that include sustainability? The answer is that the Commission does not have a mandate to intervene in mergers solely because they are likely to harm the environment, as seen in Bayern Monsanto. We cannot just say the deal is a harm to the environment and the Commission will block the deal. There has to be some impediment on competition. So far, these innovation theories of harms have been used in pharma cases and in tech cases, where we also look at quality issues. Is there a significant impediment on quality and not only on price if the two companies merge? And so maybe we will see a shift here to also include sustainability, as sustainability is connected to quality maybe, and there is room to also use innovation theories of harm in sustainability merger cases. Next slide, please. When looking at a merger, the parties have to substantiate any possible efficiencies that may outweigh any impact, any negative impact on the markets. But efficiencies have to benefit customers. There has to be a likelihood of pass on. They have to be merger specific and verifiable. And this is quite difficult when it comes to efficiencies regarding ESG. A merger may bring about improved quality products, e.g. by decreasing the level of toxicity, generating less waste, using less raw materials, or maybe having an impact on transport and long distance. It can also result in new green products. But the Commission has to assess whether the efficiencies can compensate for a potential harm in the relevant market. If the merger, for example, would lead to less CO2 emissions in Asia, but there is a negative impact on competition in Europe, the Commission cannot use these efficiencies to outweigh the harm. The efficiencies have to occur within the market where the competition concerns are found. And the Commission sees itself bound by the MasterCard decisions, which dates back a while, where the principle of efficiencies needs to be in the same market was established. So same as for the horizontal guidelines, as Francesca just explained, also for mergers, there is at the moment no recognition of out-of-market efficiencies. Next slide, please. Are there green remedies? Some stakeholders urged the Commission to always accept the greenest remedy, or even impose remedies to deal with any possible environmental harm, even if such harm does not translate into harm for competition. And to cut the long story short, the Commission does not have such power. First, parties need to present remedies to the Commission. It cannot just make up remedies that it might see fit to issue the case. However, this does not mean that remedies cannot have a positive effect on the environment. And in fact, in many instances, there were divestments of a green or very innovative business that in the end led to the deal being able to be cleared. In GE Alstom, for example, the remedy taker finalized plans for energy-efficient gas turbines and was very successful with the business. The divestment led to the deal being able to be cleared. Also, in the Zika case that we just mentioned, the parties offered a remedy, the divestment of the very innovative business, which in the end led to the parties not being horizontal competitors. And the Commissioner Vestager said that following the remedies offered by Zika, customers in Europe will continue to have a competitive choice of chemical admixture supplier. And this business was seen as very important to meet sustainability challenges in Europe. So the Commission hence considers green remedies where the threat to competition is also in a way green or innovative. But the Commission will not accept or impose remedies simply because they would mitigate potential environmental harm in the markets concerned. Next slide, please. And the Commission says there's one particular concern when it comes to the European Green Deal and achieving the goals we have set for us. And this is green killer acquisitions. A killer acquisition, we try to define it, is an acquisition in which a company acquires innovative targets with the sole purpose to discontinue its innovation project and preempt potential competition in the future. So really to buy a business and kill the business. And this, of course, can be a problem for innovation because those small, maybe startups, companies are very relevant for the green innovation. Why are they not caught by merger control? The problem is that we have, or the good thing is that we have merger control thresholds. And with startups, the problem is that they have very often little to nil turnover. And the deal will then likely fall below the merger thresholds so that no competition authority can deal with it. However, the European Commission and the national competition authorities are very lucky to have Article 22 EUMR. And this is a clause that was not dealt with for a long time, but now has been reintroduced as the new referral mechanism. And the principle is as follows. When there is a deal that does not meet any merger control thresholds, but a national competition authority thinks that it may be an impediment to trade between member states, and that it has a significant impediment for competition in that member state, it can refer the case to the European Commission, even though no market share thresholds are exceeded. And the Commission states that it also assesses whether the target is an important innovator. So there is kind of a risk that those deals, those killer acquisitions or deals where bigger companies like to buy in innovative companies that are per se under the radar might come on the radar due to this referral mechanism. And there are quite a few cases at the moment where the Commission reviews a deal based on Article 22 EUMR. And I think that, well, Logan, we talked about this before this webinar, and I understood that when it comes to ESG impact and merger control, there is not so much to talk about in the US, but when it comes to killer acquisitions, indeed there is.
That's true, Elena. Thank you. Yeah, the big picture story in the US, once again, is we don't have any special rules or exemptions or frameworks that apply to an analysis of a transaction in this space or a transaction that could be justified with a sustainability benefit to consumers. In fact, in September of 2022, in another example of how politicized this issue has been in the United States, the US Senate Judiciary Committee had a hearing and called the head of the Antitrust Division of the Department of Justice, Jonathan Cantor, and the head of the Federal Trade Commission, Lena Khan, in to testify. And they asked them a bunch of questions about rumors that the Federal Trade Commission in particular had been approving deals on the basis of ESG policies or conditioning approval on the adoption of an ESG policy. And the head of the Federal Trade Commission, Lena Khan, testified that she would absolutely not condition merger approval on a company's adoption of a particular set of ESG policies. And in fact, she said that she had seen companies coming into the Federal Trade Commission arguing that the agency should bless a transaction because it was going to have some environmental benefit. And she said she does not find those types of arguments compelling. And she doesn't think that ESG commitments or anything in that vein could ever rescue what would otherwise be an illegal deal. However, while there's no express framework that we would use to apply to these transactions that's different than the standard, the U.S. antitrust agencies did just recently put out some new guidelines on how they think about and review mergers. That would have been an opportunity for them, for example, to clarify how they would define markets in a case involving sustainability. They chose not to do that. But we do know that the current FTC and DOJ often define markets narrowly, and they talk about that in their new merger guidelines. And there is some precedent for narrower product markets in consumer products spaces that involve organic or premium products. And for example, the Federal Trade Commission went to court to block a combination of two grocery store chains in the United States that offered what they called premium, natural, and organic food, Whole Foods and Wild Oats. And that was a number of years ago, well before the rise of the politicization of this issue in the United States. So there is some history or precedent for that idea and market definition here in the US that is reflected, at least implicitly, in the current guidelines. And then, as Elena mentioned, in the US, killer acquisitions are also a focus of the antitrust enforcement agencies. And you see that also reflected in the guidelines, where they talk about how a series of acquisitions, even if none of them are on their own anti-competitive or even, maybe not even reportable to the US antitrust enforcement agencies, could be viewed as anti-competitive in the aggregate, even if none of them would violate the law on their own. And I could see how the current administration might try to apply that principle to acquisitions, in particular of innovative companies that have sustainability objectives. So that's merger control. Thank you. Let's talk about the third topic now, which would be unilateral conduct or abuse of dominance. Francesca, can you tell us how this concept could be relevant in the area of sustainability?
Sure, Logan, thank you very much. Well, as Elena pointed out earlier, sustainability plays a role in the Commission's assessment and decisions in various areas, in merger control areas, in the state aid area, in the horizontal agreements area, and also in the abuse of dominance positions area. There is, next slide, please, a very recent press release concerning a new investigation less than 2 months ago. The Commission announced that it sent a statement of objections to the main Greek electricity producer, which is partially public. The Greek state owns an important minority stake in it. And the theory of harm here, it's very interesting, because the Commission is accusing PCC of having abused its dominant position by supplying electricity produced in its thermal plants below variable costs. And the effect of this pricing practice would have been that independent electricity producers would have been marginalized. They would have been squeezed out or at least set on the margins of the electricity market. And by not being able to sell as much as they would like to do to consumers, they would have produced less revenues, and this would have impacted on their ability to invest in green technologies to produce electricity. So the outcome would have been not only an increase in the price of electricity for consumers, because of less competition on that end, but also on higher emission levels of local pollution because of less substantial investments in greener technologies. It is a very interesting theory of harm, and it will be certainly extremely interesting to see what approach the Commission adopts and also what kind of defenses the Greek electricity producer raises against these objections. But it's just at the very, very early start, so it will take a while before we have a follow-up on this case.
Thank you, Francesca. And I know I sound like a broken record, but in the US, we don't have any special rules that would apply here to issues involving sustainability. We do have enforcers at the moment who are aggressively going after companies for unilateral conduct that might not have been challenged in previous administrations. The US FTC and DOJ have brought some big unilateral conduct cases against some of the biggest American companies in this administration. So it wouldn't be a huge surprise if they were to pursue a unilateral conduct case that did involve an issue regarding sustainability, but it would not probably be for that purpose. In that September 2022 hearing that I mentioned, Jonathan Cantor testified, the head of the Department of Justice Antitrust Division, testified that when firms have substantial power and they use that power to achieve anti-competitive ends, that should be actionable under the antitrust laws, whether it relates to sustainability or ESG stuff or not. So I think that's the lens that they're going to look through when they're trying to assess whether to bring a unilateral conduct case here in the US. So those are our three topics. Maybe we could just spend a minute wrapping up and talking kind of big picture about what all this means and what we should be thinking about going forward. We go to the next slide. Ches, what should we be thinking about in the US?
Yeah, sure. Well, obviously it's an election year here, so a lot is going to be contingent on the results in November, not only for the White House but also in Congress. In addition to the state AG investigations and President Trump's previous term, you see members of Congress that are sort of Trump aligned. House Judiciary Chairman Jim Jordan has begun his own investigation into companies that have agreed to sort of ESG priorities. In the letter that he sent to companies, he wrote, this sort of sums up the Republican point of view, or at least that wing of the Republican point of view. Woke corporations are collectively adopting and opposing progressive policy goals, but when companies agree to work together to punish or disfavor views or industries, or to otherwise advance ESG goals, this coordinated behavior may violate the antitrust laws and harm the American consumer. So that's kind of the Republican, at least Trump side of the party point of view. I think that will be highlighted a lot throughout the election, and I would imagine that they would continue to pursue those if Trump wins the White House and Republicans maintain control, at least in one of the houses in Congress. There's also, if Biden were to win, I think he would sort of continue with the antitrust enforcement regime and priorities that they have had in the first term, especially looking at big tech. But I think you will see Democrats push back as companies maybe withdraw from ESG commitments because of this political pressure. You can see Democrats then try to exert pressure on the other side and force them to sort of live up to the commitments they've made. So it puts companies in a difficult political environment, at least for the next 6 months, but likely longer.
Yeah, thanks, Jess. I mean, if I could have $1 for every time I hear the word woke between now and November, I could retire a happy man. Yeah.
Yes.
This is definitely going to be front burner.
Yeah.
How about in Europe?
Well, we think that based on what we have just heard, there will likely be a stronger divergence of decisions from different competition authorities, be it within the European Union, where, for example, the Dutch ACM is very proactive with regard to ESG, or the Federal Cartel Office, or be it apart from the European Union, for example, with regard to the US. So where you have a deal or a collaboration that might have effects on both sides of the Atlantic, be very clear about what kind of ESG efficiencies or other ESG considerations you might have, because those might work here in the EU, but they might not work in the US as well.
That's a great point. Thanks, Helena. So with that, I believe we have finished our presentation. We can go to the next slide, and we have the CLE code for you. 426030R. And we have a couple of minutes. If people have questions, we would open the floor up for those. You can post them in the Q&A. I'm happy to throw one out in the minute or two that we have left for my European colleagues. So if we have this tension, Elena, that you just mentioned between EU and other jurisdictions and between member states within the EU, how should companies think about the risk of conflicting decisions, and what should they do about that, if anything?
Yeah, that's really difficult. There's like one way to look at this, and I feel that many companies use this way at the moment, which is not very good. They just don't do a project because it's so cumbersome and so difficult to discuss with several antitrust authorities. But we have made very good experiences with just discussing a project with competition authorities. So if there is something you would like to do, market shares are a problem. We have some ESG thinking in it, but we are not sure whether it will work. Just discuss it with the authority. They are very open, in particular the German and the Dutch one, and also the European Commission, to helping companies achieve the goals of the Green Deal.
I may take this question also more relating to the horizontal competition, the cooperation agreements. In principle, there is no potential for conflicting decisions if you consider the EU Commission and the competition authorities in the EU member states. First of all, because there is a different sort of jurisdiction, so it depends on whether the affected market is the local market or whether it is a wider market. And also because there is a principle of supremacy of European law vis-a-vis national competition law. However, I'm thinking that actually this could lead to some sort of, so to speak, forum shopping, because companies may be somehow considering where they want to enter into sustainability agreement, sort of preferring or selecting the jurisdiction that has a more open approach, a more flexible approach that considers, for example, out-of-market benefits in a more substantial way than the Commission, which actually does not. So there is room for maneuver there.
Great, thank you, Francesca. Could we quickly go back to the CLE code slide? I just tried to share it in the Q&A, but I'm not sure if that worked. And we did have a request for that. 426030R. Great. And with that, I believe we are at time, so we should wrap up. Thank you all for joining. We really appreciate it. And if you have further questions on this topic or things that you would like to discuss, do feel free to reach out to any of us. We'd love to continue the conversation. Thank you. Have a great rest of your day.
Thank you.
Thanks all.